So on this video, we are going to do a summary of the sick and safe time policies and also things that you need to know, things that you need to communicate to your employees, stuff like that. So the sick and safe time law goes into effect on January 1st of 2024. And most of you I have worked with to set up a policy that either incorporates your current PTO policy or brings in the policy that didn't exist before for the sick and safe time. The first thing I want to say is if you don't have a policy, your current PTO policy, if it meets or exceeds the guidelines of sick and safe time, then you do not need to have an additional policy or time that you give to your employees for the sick and safe time. But if you are going to do that, there are a few things that you want to know so that you are certain that it's going to actually meet or exceed the guidelines. Sick and safe time applies to all W-2 employees that anybody for our company would be working with. There are a few types of work, such as the building or construction industry or air flight carrier, that it doesn't apply to, but we don't have to worry about that. It does not apply to independent contractors, and it applies to anybody that works a minimum of 80 hours per year. I think most employers should assume that all of their employees are going to work more than 80 hours. So it's probably easiest to just go ahead and pretend as though they're going to, and then all these things apply. Sick and safe time is accrued at 1 hour of sick and safe time per 30 hours worked. So what that means is that for every 30 hours that your employees work, they accrue 1 hour of sick and safe time. It can be used as soon as it is accrued, and there is no waiting period for them to be able to use it. The maximum amount that if you're going to stick to the sick and safe time laws that you have to give your employees is 48 hours per year. So that is 6 full 8-hour calendar days. If you are only going to give your employees the minimum amount of 48, you have to allow them to carry over any hours that are not used for a maximum of 80 hours that are allowed in that PTO bank. So as your employees accrue hours, if, for example, during the first year they don't use all their hours, it would roll over to the second year. And then they would continue to accrue hours up to 48. And at some point, if they're not using all their hours, they will get to 80, and that's the maximum amount. And when your employees get there, you do not need to keep giving them sick and safe time. They need to use some of their hours in order to then go back to accruing them. This applies for, like I said, all employees. So that's full-time employees, part-time employees, seasonal employees, all those types of categories. If you have an employee that is salaried, you are going to measure their sick and safe time based on their average amount of hours that they work. So if that's 40, use 40. If that's 32, then use 32. If you have employees that are commissioned and you're only paying them for an actual service and not necessarily for their hours, what I've encouraged some of our other clients that have that situation is to go to their employees and find out the total amount of hours that they're putting into whatever that set amount or commission rate is, and then to divide that up. And that's the rate at which they would pay sick and safe time. If you decide that you don't want to carry over sick and safe time, the other option is to front load the hours. And what that means is that every year you need to give your employees 80 hours per year. And that is if you decide you don't want to have them carry them over. Now, you would not need to give them 80 hours on the first year, because in 2024, the maximum amount that anybody could ever accrue would be 48. But starting in 2025, if you want to front load the hours, that is fine. To not have to then deal with, all the calculations that go along with when the hours accrue. But the downside to that is that you will have to front load more hours, because in order to meet the minimum, you would have to give them 80 hours per year. And then the other thing is that if they do not work the entire year, they have a chance that they could use all their hours without having had accrued them because they didn't work enough. So that is completely up to you for how you choose if you want to front load them or give them as they are earned. If you are having the sick and save time be a part of your PTO policy, that what needs to change for your PTO policy are a few different things. Number one, I think I have it in here, but if you give them PTO, what that means is that it can be used for whatever they want. It does not have to meet these requirements of how employees can use sick and save time if you're going to call it PTO. So they can use it for vacation. They can use it just because they want to take a day off. And additionally, though, they have to meet the requirements of sick and save time, which means that for taking off PTO, they do not need to find a replacement worker. You can't make them responsible to do that. And also, they don't have to give more than 7 days notice. For some policies I've written that employees are allowed to give more than 7 days notice if they so choose, but it is not required. So if you are choosing to go with the sick and save time policy as opposed to the PTO policy, then you can have restrictions on how those sick and safe hours can be used. And I have a list of them here. It can be for the employee's own physical or mental health, including preventative health. It can be for the care of an employee's family member, for their physical or mental health or preventative health. It can be absences related to domestic abuse, sexual abuse, stalking, any of those types of things that they may need time off in order to take care of issues related to that. It could be for weather-related public emergencies, for business closures. It can also be taking care of a family member whose school or work has closed due to weather or a public emergency. So this would include if you have an employee and they have kids and their kids' school got closed because of a snow day and they need to stay home and take care of their kids, they could use one of their sick and safe days. It also can be used to prevent transmitting a communicable disease. And so this clause kind of has to do with like COVID. If someone is COVID positive or has been exposed to COVID, then they could use some of their sick and safe time to be able to take the time off in quarantine and not be in contact with other people to potentially spread that. So as I had previously mentioned, employees can be required to give up to 7 days notice of the time that they're going to take off. If it is not a foreseeable occurrence for why they're taking the time off, then they're to give as much time as possible. And again, they do not need to find a replacement worker to cover any of their shifts when they are going to be gone. A couple other things I want to touch on is giving your employees the sick and save time is mandatory as it is part of a new Minnesota law. And so although it may financially cause a strain on your business, two things I want you to know. Number one, like I said, it is mandatory, so there's not a whole lot you can do about it. Number two, if you go with the sick and save time policy as opposed to PTO, you just know that because it cannot be taken for anything, there are certain employees that either maybe they don't have health issues or they don't have a family member that has health issues or they don't have children, and therefore they may not have the opportunity to use all of their sick and save time, hence why they're allowed to carry it over from year to year. So you don't want to automatically assume that you're going to be paying out 48 hours of sick and save time like you would for PTO for each employee, because not every employee will use it all. Things that you need to know as an employer is on the policy, there are some mandatory things that need to be on there. For those of you that I've written your policy, it is on there. But there are a couple of paragraphs that need to be on there. And those include these paragraphs here that employees will be required to give notice to the employer. That paragraph that starts with that. And then the next paragraph, if documentation is requested, employees must provide one of the following: either a signed statement by a healthcare professional or a court record or documentation. All documentation and communication surrounding sick and save time between employers and employees must be kept confidential. You also have to have a paragraph on here that talks about that employees will not be discharged, disciplined, penalized, interfered with, threatened, restrained, coerced, or otherwise retaliated or discriminated against because they have attempted to or actually exercise their right to use sick and safe time. Even if you have a PTO policy and you don't have a specific sick and safe time, these things need to be on there. If you had PTO and not sick and safe time, you wouldn't need to have this paragraph that talks about providing documentation because you are allowing them to use it without ever needing to provide documentation. But even if it's just a PTO policy, you will need to have these two paragraphs here of that they will not be retaliated against if they choose to use it. And then the second thing is that they have the right to file a complaint or civil action against the employer if that using the sick and safe time or PTO is denied by the employer. So those are the necessary things that as an employer you need to have in your policy if it's not already on there. The second thing I want to tell you is that you need to make sure to talk to your payroll company. And they should be aware of this and they are prepared for this to know that they need to be tracking your employees, that they are accruing it, that it needs to show up and have on their payroll statement how many hours they've accrued, how many hours they used in that particular pay period. Those types of things need to, the status of those needs to be on each payroll statement so that employees can keep track of it. And it also will assist you in being able to keep track of it. So I have in this document that sort of summarizes the sick and safe time policies and laws. I have 3 sample policies, and I think I emailed this to most of all of our general counsel clients, or it is in your Google folder with us with all of your other general counsel documents. But I put in here a couple different options, starting with if you have an existing PTO policy, that if you'd like to have a separate sick and safe time policy, you can do that if you want to keep the 2 separate. I would say that that is going to be the most cumbersome for you to be keeping track of all of those because you're keeping track of the PTO accrued and then you're keeping track of the sick and safe time accrued. And you're also going to have to keep track of when hours are used, which one they're used for, and then, subtracting that from each bank. It is a possibility if you, for example, don't want to have the same loose restrictions apply for all of the time that they receive. Like I talked about with sick and safe time, it has to only be for specific things like for your own health or a family member's health. So it is possible for you to have both a PTO policy and sick and safe time. And if you choose to, you can decrease your PTO policy. I think that a lot of employers don't realize that PTO is not mandatory to give. Benefits in general, unless your employees have signed and bargained for or negotiated for those benefits, and it is part of their employment agreement, benefits are subject to change by most employers. So if you choose to decrease your PTO policy to then accommodate for the sick and safe time, that is within your rights. The only other thing that I want to mention is with the new policy, you want to make sure that you provide all of your staff with that so that they have an opportunity to know what is going to be coming. Ideally, that would be done before the first of the year. You can email it to them. It does not have to be in paper form, and you do not need them to sign it. It's just notification to them that the policy has changed in some way or that there is a new policy that will be implemented. Those are pretty much all of the main points, other than and this is in the bullet points of the policies. And so if you guys have read over those, you should know this, but I'll just go over it really quickly. Like I said, the sick and safe time is paid out at the same rate as the employee's hourly rate. If you have someone that's salaried, they can take their sick and safe time in increments as little as 4 hours at a time. If you have an hourly employee, they can take their sick and safe time in increments as little as 1 hour. And again, there's nothing hindering you from giving more time, whether it is PTO or sick and safe time. You are free to do as you choose, as long as you are meeting the minimum requirements based on the law. For sick and safe time, I talked about the different eligibility things for what people can use it for. I also just want you to be aware of that for the purposes of this law, the phrase family member is defined very broadly. So it includes what a lot of us consider to be a traditional family member, such as like a child or our spouse or a domestic partner or our sibling or our parent, all of those types of people that we would think about traditionally as a family member. But it does also include people through marriage, and also each individual can appoint one person that is not in any way related to them, either by blood or marriage or any other way by law, and can appoint them as someone that is still considered a family member. So, for example, if you had an employee that was very close with their next door neighbor and from time to time provided care for them, and their next door neighbor needed to go to the doctor, and your employee typically took them to the doctor and asked for time off to be able to do so and to use their sick and safe time, that would be within the confines of the law. They would be allowed to use that for someone that isn't technically their family member if they have appointed that one person as the person that they would like to include. And that person can change on an annual basis. If you so choose, you can have your employees in writing appoint who that person is. Otherwise, you can just sort of in good faith, hope that they wouldn't abuse it and say, oh, well, I'm taking my neighbor and now I'm taking, my best friend to the doctor and whatever it might be. But according to law, you can have them designate someone, and that can be changed on an annual basis. I think that is all. You are free to email us at Holt Law if you have any additional questions. My email address is jlc@holtlawllc.com if you have any questions about this. Otherwise, I hope that this video has been helpful, and I will be also writing up sort of a bullet point thing that talks about the things that you need to know as an employer and the things that you'll want to tell your employees about this policy as you go over it with them. Thank you.